Hello, everyone. Welcome to our Legal Basics webinar. We're going to give it a few seconds for people to get logged in. And welcome, everyone. We're just giving it a few seconds for people to get logged in before we get started. Right. Good afternoon, and welcome to the Indiana Youth Institute's webinar, Legal Basics for Youth Serving Organizations, Part 2. My name is Whitney Johnson, and I am the SYPI Project Manager at IYI. Thank you again for joining us for today's presentation. We are grateful to have the chance to connect as a community of Indiana youth workers who remain committed to meeting the needs of our youth and children. For those who are not familiar with IYI, our mission is to improve the lives of all Indiana children by strengthening and connecting the people, organizations, and communities that are focused on kids and youth. Listed here, you can see our vision that drives the work we do for Indiana youth. And before we begin, I'd like to share a few pointers that will help you engage with today's webinar. For any technical support issues, use the chat feature to send a message and I will assist you. Use this feature to converse with the group as well. We also encourage you to ask questions, so please use the Q&A feature for any that you may have, and we will get to as many as possible. Feel free to also upvote great questions to the top. Later today, you will receive an email with a link to complete an evaluation of this webinar. Please take a few minutes to let us know your thoughts about today's presentation. And if you don't receive the evaluation email, please check your junk email as it may have been directed there. Once you complete that evaluation, you will be redirected to your certificate of participation. Like all of IYI's webinars, today's webinar will be posted on our website. I know a lot of you have questions about that. So if you'd like to revisit a portion later or share the opportunity to listen in with partners. It is now my pleasure to turn it over to our speakers for today.
Thank you, Whitney. And hello, everyone. My name is Joe Miller, and I'm a partner in the Indianapolis office of the law firm of Faegre, Drinker, Biddle, and Reith. We are a global law firm, but we have really deep and broad roots here in Indiana. Many of you may know our law firm by its former name, Baker and Daniels, and then we were Faegre Baker Daniels for a while. We are now Faegre Drinker, but we have not only a very deep set of practices across the firm, but those practices are very well represented here in Indiana, and in particular, the nonprofit organizations practice, which I lead, has a really long history of serving organizations across the state. And I would say that on a personal note, it's been my great privilege to work for nearly 30 years with IYI and with many of the organizations that IYI serves. And so I'm really grateful for the opportunity to speak with you today. And I want to take a moment and introduce two of my colleagues who will be presenting with me today. Heather Moore, who you see here on this slide, is also in our nonprofit organizations practice. Heather has been with the firm for about 18 years, and she advises nonprofit organizations on a range of legal challenges, addressing their comprehensive needs on everything from formation of organizations to internal governance, compliance, general tax advice, and preparing related documents and policies. She has a particular experience with community foundations, colleges and universities, fraternal organizations, and something that's particularly helpful for our conversation today, a good chunk of her practice focuses on the preparation and execution of gift instruments whereby philanthropists make charitable gifts to nonprofit organizations, and that'll be a particular focus for her today. Also joining us today is our partner, Dory Kane, also here in the Indianapolis office. Dory is in our privacy and cybersecurity practice and helps lead that practice across the firm. Dory helps clients navigate emerging challenges related to today's digital economy. She helps clients understand their information practices and helps them address the life cycle of data protection issues, from ongoing privacy and cybersecurity counseling to building data governance programs. And we're very, very grateful that Dory was able to join us today. She brings a whole lot of experience and expertise to bear, and I can attest to that directly, as she and I collaborate quite often on privacy and cybersecurity matters for nonprofit organization clients. Today's part two of the ongoing sort of legal basics for nonprofit and youth serving organizations. And there's a bit of randomness, I suppose, to the topic coverage, but we tried to pick topics that would be of the greatest interest to the greatest number of you. And so today's session really is divided up into three parts. The first part will be general contracts and agreements, general observations on contracts and agreements, to kind of help you just have a framework for understanding best practices as you enter into contractual arrangements with other organizations, with individual service providers. So by no means is it a comprehensive overview, but it's designed to give you some of what we think are the most important and most helpful observations, tips, and maybe pitfalls to avoid. So that'll be part one. Part two, we'll get a little bit more specific to a particular kind of contract or agreement, and that is gift and grant agreements. I alluded to that a moment ago, and Heather will be taking us through similar set of observations and best practices and some statutory requirements in some cases for gift and grant agreements. And then we're going to do a pivot in the last part of this session, and Dory will give us an overview of data protection best practices and the most important things to watch out for from a legal perspective. So with that as sort of our setup, we'll move on into the first part, which is our contracts and agreements discussion. And we'll move to the next slide. And I'll just spend a few minutes walking us through what we think would be the most helpful things to remember for you as organizations as you enter into contractual relationships and as you manage existing contracts. So the focus here is really, we've tried to focus particularly on independent contractor and service agreements. That is when you as an organization engage either an individual or a company to provide services to your organization. So from a content perspective, these agreements, sometimes I like to say, if you've seen one, you've seen one. Not you've seen them all, but you've seen one. And so the content will vary based on the nature of the services, particularly in the first part of the agreement. We can't possibly, sort of cover all types of circumstances when it comes to covering all bases of these kinds of contracts. But we are going to hit some of the high points that are sort of repetitive and tend to appear most often, and try to steer you clear of the landmines that we often see. So we'll move to the next slide. On this and the following slide, we're going to talk about provisions that we really feel like ought to be in every contract. That's why we've called these slides required provisions. Content will vary, but these are topics that you really need to address in any contract with a service provider. So for starters, maybe it's super obvious, but you want to describe the services that you're obtaining from your service provider or contractor. So sometimes you'll want to bake this description of services right into the agreement itself in one of the first sections of the contract. But almost, I would say more often, what we see is an attachment or exhibit to the contract, which allows you to not, go for pages and pages in the contract itself, but simply refers to a description of services to be provided, for instance, a statement of work. And so oftentimes that'll be exhibit 1 or exhibit A to the contract. And you want to be as specific as you can be in describing these services, so that you can assure that you're getting what you pay for. The next provision that ought to be in every contract is defining the term of the agreement. And we're still back on that same slide. Thank you. And by term here, what I'm talking about is a time frame. And what you want to make sure you specify is, number one, what's the date on which the contract will take effect? We call that the effective date. And just as importantly, when does the agreement expire, if ever? Sometimes you'll have sort of an automatically renewing perpetual contract. That's pretty unusual. But you ought to have a beginning date. And unless you've really intentionally agreed with your service provider that this is just ongoing, you'll want to have sort of a default end date, unless you actually have a reason to terminate that before the end date. So fix your term and refer to both your start date as the effective date and your end date in the term provision. Early termination, which is this third section on this slide, you ought to have a provision that contemplates under what circumstances the contract can be terminated early. That is, prior to the presumptive end date of the agreement that you've identified elsewhere in the contract. For instance, a material breach of the contract by either party. Or if there's reason to do this, and sometimes there is, you might both want the opportunity to exit the relationship early with no cause. But if that's the case, what you'll want to do is provide a very specific roadmap for how to do that. For instance, how much notice is required if you're going to terminate early without any cause? Should you be required to provide 90 days notice, 30 days notice? And particularly if you're going to require some sort of cause for early termination, you'll want to identify with some level of specificity what it is that will constitute that cause. Sometimes you would just see, you can terminate with cause, and that just kind of begs a question which can lead to an exhaustive battle, potentially in litigation, about whether cause actually occurred. And so you might want to define cause at least as a breach of one of the material terms of the agreement, or a failure to be responsive or provide services in a meaningful way. And the contractor may say, if I don't get paid within a certain amount of time, then that's cause for me to exit early. So early termination provisions. Then the last of the items on this slide deals with how the contractor or service provider is going to get paid, how much, how frequently, and kind of what's the arrangement there. So there ought to be, first of all, a description of the methodology for payment. That is, are you going to be paying a flat fee for a project? Are you going to be paying by unit of work, for instance, by the hour? Maybe somebody charges, say, $50 an hour for the services that they provide. You ought to, first of all, fix that in the contract so that it's very clear what the methodology for payment is. And then after you fix that, you want to make sure that you set forth the process for invoicing. That is it automatic that you just pay on the first of every month? Should you require an invoice from the contractor, on the other hand? And I would probably recommend that, particularly if you are paying by unit of work, because that's going to be a variable amount. So there should be some provision for the contractor invoicing you and what time period you have to respond to that invoice with the actual payment. And then in addition to the fees that you pay, there ought to be some contemplation of whether and under what circumstances you're going to reimburse expenses that are incurred by the contractor in the course of performing services. We would highly recommend requiring prior written approval of expenses, that the contractor should not simply be able to invoice for any expense with no prior notice. It could be that certain expenses are going to be incurred on a recurring basis, and you can detail those in the contract and say no prior written consent is required to incur these expenses at certain amounts. But other than that, if somebody is going to be traveling or may need to travel, you ought to have a provision that says prior written authorization for that expense reimbursement before the expenses incurred is required in order for you to reimburse. Next slide. So the last few provisions that we say ought to be in just every contract, the first of the ones on this page deals with the confidentiality of information that is shared during the course of the relationship. We would really recommend that at least you have what we call here a one-way confidentiality, which is any information about your organization that the contractor obtains during the course of performing services that is by its nature confidential needs to stay confidential. And there ought to be a provision that says that the contractor cannot share that confidential information, at least without the written consent of your organization. In some cases, it might make sense to make that two-way, to make it a mutual confidentiality undertakings where you also agree to maintain the confidentiality of the contractor's confidential information. And by the way, when I talk about confidential information, it's pretty typical to see a definition of what it is that's confidential. Not all information is confidential. For instance, information that is already known in the public without it being shared by the contractor with you. And so it'll be important to specify what constitutes confidential information, and then the rest of the provision addresses how you handle that and the efforts that both of you will take to maintain the confidence of that information. The second of the three items here deals with the relationship of the parties, and we say here, i.e., clarification that the contractor is an independent contractor. This might be super obvious to everybody, but it's really important in your contract to state very expressly that this contractor is not an employee of your organization. You do not want there to be any doubt about whether you are, for instance, required to withhold and remit employment taxes in connection with the services provided by this individual. You would not want other legal responsibilities of an employer with this individual. And so if this is truly an independent contractor arrangement, then there ought to be a provision that really sort of underscores the independence of the parties from one another. It ought to also specify that contractor does not have authority to act on your behalf, cannot go out and make legally binding obligations on your behalf. They're not empowered to do that unless there's a very specific thing that you've empowered to do, and you would say so in this provision. And by the way, the last point here in this particular item says, should similarly clarify that the contractor sets his, her, or its own hours and is responsible for all taxes. That's important to establish that they are an independent contractor in the first place and not an employee. So you're reciting that they have control over the way in which they do the work for you, the hours that they keep, and the manner in which they provide services. That will help you avoid a conclusion by law that somehow you're their employer, which you, again, do not want. The last item here on this page is indemnification. That's a term that is often sort of misunderstood or just not understood. It sounds kind of exotic, but it's really pretty straightforward. Indemnification is one party's agreement to make the other party whole if a third party makes a claim against you for liabilities that actually arose because the other party was responsible for them. So if your contractor, for instance, were to provide services in a way that causes a third party to make a claim against you for, say, intellectual property related reasons, or they physically harmed somebody in the course of their services, they find out that contractor was doing work for you when that happened, so they sue you. The indemnification provision is designed to ensure that you are able to receive indemnity, that is, to be made whole by the contractor. And again, here, like with confidentiality, it ought to be at least one way. You definitely ought to receive indemnification from the contractor. In some cases, contractors will push back during the contracting process and say, hey, we'd like to have you indemnify us too, if for whatever reason we, the contractors, are put on the hook by a third party for things that were your organization's fault. Next slide. Now here we're going to move to what this slide calls standard terms. I sometimes refer to these as boilerplate terms. It's not because they are unimportant. They're very important, but they are, as this slide indicates, very standard. And unlike the provisions that we just discussed, These typically have content that's not particularly variable. The same core content probably ought to appear in just about every contract you make with an independent contractor. So we'll just kind of fly through these. Governing law, that basically says if a dispute arises about this agreement, what's the law, what state's law will govern the dispute and how it's handled by a court. And if your contractor is in Indiana, and even if they're not, because you're in Indiana, we would always recommend specifying Indiana as the governing law of the contract. The second item is called severability. That basically just says that if for whatever reason a court finds any particular provision of your contract to be unenforceable, for whatever reason, maybe they find it to be against the law, that you can't have a provision like that, or that it's unenforceable for whatever other reason, that doesn't void the rest of the contract. This basically just helps your contract stay in place, even if one little piece of it is found to be unenforceable. The entire agreement standard term is basically designed to leave no doubt about the fact that this document is the book, this is the rule book that governs your relationship in a contractual sense. You may have had a number of oral discussions. You may have had some emails that have gone back and forth to get to this point, but this represents the entire agreement of the parties. It supersedes any and all prior understandings, whether written or oral. I think that's language that I typically see. And that, very importantly, it can only be changed or amended if both parties agree to do so. So, again, kind of maybe obvious, but it's really important to say this is the document. Otherwise, if push comes to shove and you find yourself in a litigation context, if you don't have a provision like that, it's possible that you could find yourself, fighting about whether 3 emails 2 months before the contract was entered into somehow are also a part of the contract, especially if they suggest outcomes that are different from that which is suggested under the contract. The waiver standard term is designed to really protect both parties, that if they don't, for whatever reason, insist on enforcing one particular right that they have in the contract, that it doesn't constitute a global waiver of every other right they have in the contract. So in other words, maybe to use an example from the contractor side, if you're late in paying them, and they don't hold your feet to the fire and terminate the contract, if they're allowed to do that and instead give you an extra 15 days to pay, it doesn't mean that they've waived every other right that they have under the contract. That's just an example. The non-assignment standard term is it's very important, and it basically is designed to ensure that you get the services provided by the contractor you have chosen. That they can't, that contract can't go out and just assign their duties under the contract to a third party without prior written permission from you. Typically, that'll be a two-way mutual provision, but it's really much more important for you to make sure that you're getting the services from the contractor. And the last item on this slide relates to notice, and that's simply a provision that will have both the mailing address, probably the email address of each party, to where official notices that are required under the contract need to be sent. So as an example, if you say, hey, we're not going to reimburse your expenses unless we've given written authorization, they need to know who to ask for written authorization. And so they'll provide notice of their intent to incur an expense, and the notice provision will provide how that's done and to whom. Next slide, and this will be the last one on our general contracting principles. These are just a couple of the landmines or pitfalls that we often see, and I have to say I just absolutely love this graphic. So it makes me dizzy just looking at it. But we often will see when we come into a situation in midstream that an agreement has not been dated and there has not been an effective date specified. And you just want to avoid that. You want to make it very clear when the relationship contractually is enforceable. What's the start date? And so typically that'll be in the very first line of the contract, what the effective date is. It's really important if you use an exhibit or an attachment, like a statement of work, to describe the services that the contractor will provide, you want to make sure that you have taken the time to compare the body of the agreement with the attachment, with the statement of work or the other exhibit that describes the services, or whatever else you're putting in exhibits, to make sure that there are no internal conflicts or inconsistencies between the body of the agreement and the statement of work. Another common area of problem that we see is, sometimes a contract will automatically renew in that term provision. It'll say this will automatically renew unless one party gives notice to the other party that it won't, that they're opting out at the end of the term. But if that doesn't exist, if there's an end date, but the parties continue to operate, and then there's a dispute about something after the official end date, the query comes up, well, is this an enforceable contract? Because it officially ended, but we kept doing business with each other. So you just want to take the time to document things properly so that you avoid that kind of a dispute. And then lastly, you want to make sure that, particularly in your case as an organization, that you have a way to get out of the contract if you need to. So you wouldn't want to be bound for a 10-year term, just to give it a kind of a ridiculous example, with no possibility of terminating early. And that goes back to the provisions we talked about earlier. So that is the conclusion of the first part of our 3 parts on common contracting issues. And we're going to move now to a discussion of gift and grant agreements. And I'm going to turn it over to my colleague, Heather Moore.
It's good to be with y'all today. And as Joe said, his focus was on when your organization is paying a contractor to do something for you, and we can go to the next slide. I'm going to focus on when your organization is receiving funds, whether by gift or grant. And this partially ties into the first legal presentation that we did, which talked about the different public charity classifications and also the distinction between private foundations and public charities. And I'm not going to spend a lot of time on that here, but it's where that distinction comes into play. So our assumption and what we understand is that most of your organizations are public charities. And so by virtue of that, you may be receiving grants from your private foundation C3 counterparts. And one thing to keep in mind is if you are a publicly supported charity, which we talked about on the last session, where you're subject to a public support test that you have to monitor and report on your 990, one thing to keep in mind is, as you accept grants from private foundations, is that those can count against your public support test. They're not fully includable in public support or subject to the 2% limitation. So just being aware that if you're accepting large private foundation grants, making sure that they're not going to result in tipping concerns where it could impact negatively your public support levels. Other things to keep in mind when we're talking about private foundation grants, typically the grant agreement will say that you can't engage in any lobbying with the grant funds. So some of you as public charities may do some minimal amount of lobbying or an insubstantial amount of lobbying, but typically private foundation grant funds cannot be used to cover lobbying expenses. All C3s are prohibited from engaging in politicking and political campaign activities. So whether you're a private foundation or public charity, that is going to apply. And so the grant agreement will similarly prohibit political campaign activity. And it will also typically indicate that the funds cannot be earmarked for any other organization because a private foundation doesn't want to be seen as maybe indirectly making a grant to another organization through you as an intermediary. So it'll typically say that the funds aren't earmarked. As you receive private foundation grants or grants in general, it's just helpful to be aware of the reporting obligations and to be aware of those on the outset. Typically, it'll be maybe an annual report and a final report, sometimes a biannual or even a quarterly report, but just being aware of those and making sure you meet those reporting deadlines. Similarly, the grant agreement should specify what the purpose of the grant is and maybe some requirements for how the grant funds will be used specifically. Just paying attention to those. If you receive a grant for a particular purpose, you can't then use those funds and actually use it for something else. You're going to have to report on it, and it would be a violation of that contractual agreement with the funder if you use the funds in a manner that differs from what the grant agreement specifies. And this last bullet point is, again, this pertains to what your public charity classification is, but to the extent that your organization is a supporting organization within C3 and within the public charity classification, if you're further classified as a supporting organization, which is a 509A3, one thing to be aware of is that generally 509A3 supporting organizations are subject to a limitation which requires you to only make grants to your supported organizations. So those public charities that you're closely connected with. So hopefully if you are a supporting organization, you understand who your supported organizations are and are aware that generally you should only be making grants or distributions to those supported organizations. There are some exceptions to that, but that's a general rule. Okay, moving on to the next one. This is just sort of an overview. We're going to look at some key concepts and terms that should generally be included in gift instruments and that you enter into with donors. But this is just kind of a high level overview of some of these important things to keep in mind. I think it's helpful to know that, especially when we're thinking about endowment funds or funds for gifts that are going to continue on, not in the short term, just to think about those who are going to come behind you. Make sure that you have clear records for what the fund is intended for, any restrictions. Make sure it's easy to find. A lot of times, there'll be a change in staff, and the current staff will not. They'll have like a very brief blurb about how the fund is supposed to be spent, but making sure there's clear records that anybody who comes behind you would be able to find and follow. I think it's really helpful to keep in mind that gift agreements should be clear and make sense for the organization in the long term. You don't want to just get money in the door, and we'll focus on this in a little bit. There's some slides that talk about this too, but making sure that the gift makes sense for the long term, and not just because, okay, we want these dollars today, we want to be able to report that we met this fundraising objective, but that the gift actually makes sense. And I think to the extent possible, building in some flexibility for the organization's use of the funds if things change. So we'll look at this in a few slides, but things like spending policies and fees, not locking the organization into specifics, but saying, as policies may be amended from time to time. But we also want to avoid really vague terms where nobody's clear on how the agreement should be governed at all. And we'll dig into each of these in the coming slides. So we can move on to the next slide. So now digging into some of these key terms for gift instruments. And again, this is not exhaustive. And some of this, and I'll try to note that as we come to them, are mainly applicable to endowment fund agreements. But generally, we're thinking about a gift that is establishing or supporting a fund for a particular purpose. So again, a lot of these will be endowment funds, which that just means that the fund is intended to exist in perpetuity. But some of them may be funds that funds a particular program for several years or something along those lines, but maybe not in perpetuity. But the first thing is just making sure that the purpose of the fund is really clearly articulated in the gift instrument. And with that language, we'll typically say, the purpose of this fund is X, Y, and Z, provided, however, that no distributions from the fund will be made if the organization determines that, they contradict in any way with code section 501c3. We just want to be really clear that you're not going to use the funds in any way that would jeopardize your tax exempt status. When you are establishing endowment funds, it's helpful if the endowment fund agreement is really clear that the endowment will only be established if a minimum amount is reached. So sometimes the donor may contribute an initial $5,000 contribution with the initial establishing of the fund and the gift agreement, and then anticipate that future funds will be forthcoming. You do not want a bunch of endowment funds that have a $5,000 balance, because what they're able to spin off in a year is going to be so small that the time and expense involved in administering those endowment funds is not going to be worth it. So a lot of times I will see a minimum in an endowment fund agreement of $25,000. Sometimes organizations are higher than that, so that the amount that is spun off in the investment income is meaningful and can make meaningful distributions to justify the organization's time in managing that fund. And so sometimes it will say, like, in the event that the minimum is not reached, the $25,000 is not reached, then the organization can use the funds for general purposes, or maybe it will go into the organization's general endowment fund, or there'll be an alternate use if that minimum amount is not reached. You generally want to provide for, and this is moving on to the number 3 there, management or administrative fees that the organization can assess against its endowment funds or funds that are held for investment purposes. And I would not specify what that fee amount is. So sometimes it'll be like 1% of the assets in the fund or something like that. I would generally just say that fees will be assessed in accordance with the organization's policies is amended from time to time. Again, to provide you that flexibility to change that fee schedule over time, but just being clear to the donor. And this is one thing that actually was litigated fairly recently in a high profile case, not in Indiana, but where an organization was administering an endowment fund, but the initial fund agreement did not contemplate administrative fees, which is a very standard and what would be expected standard term. But the donor was generally just upset with how the organization was administering the fund. And this is one of the things that they pointed out was that, fees had been assessed, but the agreement was not clear that that would be the case on the front end. So just making sure that that's included as if you do intend to charge fees. Next slide. Modification, and we're going to have a whole set of slides at the end that look at modifying institutional funds and how we go about that. But it is really helpful if the initial gift agreement is clear on how the fund can be modified to the extent the organization needs to. I wouldn't just say that the organization can modify it at will for any reason. But if there are certain circumstances that warrant modification, that the organization can do that. Again, you don't know what circumstances are going to change in the next 30, 40, 50 years if it's an endowment fund that exists in perpetuity. And so typically language that would allow you to modify in the event that, the current restriction becomes impossible or impracticable for the organization. Another similar issue related to modification is specifically with scholarship funds. And I don't know how many of your organizations administer scholarship funds, but articulating what happens in the event that, the specific scholarship criteria can't be met. Sometimes there'll be a scholarship that supports students at a particular school or something. And what happens in the event that that school closes or there are no eligible students, just making sure you provide for those contingencies. Next slide. And again, these are the final key terms, I think, that are important for gift instruments. The spending level, especially when we're talking about endowments, what is the spending policy? And so typically, again, I like to keep this flexibility. And so not saying that an older agreement, sometimes you will see that it specifies a spending rate for the fund. So maybe a 4% rate or something. I think what's more common now, and I generally prefer is to say that the organization will establish a spending rate in accordance with the organization's spending policy as it may be amended from time to time to give you the most flexibility. It becomes really challenging when you have multiple institutional funds that have varying and different spending rates to manage those. It's much easier if all of the funds are governed by your spending policy, and that spending policy can fluctuate as needed from time to time. And then investments, similarly, providing that the funds that are held in the endowment fund or the institutional fund will be invested in accordance with the organization's investment policy, as it may be changed from time to time. And again, just trying to provide you that flexibility and the board to make changes over time without needing to actually modify the terms of the gift instrument. Next slide, please. And this gets to one of those first key points that I was talking about. I think sometimes there is a temptation to just get dollars in the door, recognizing how hard it is to fundraise. And when you get a donor who's excited about a program, the temptation is just to say, yes, we'll take it with whatever, restrictions or conditions the donor may have. But it can really be a challenge to modify a gift instrument, and then you have fiduciary duties to manage that fund in accordance with how the gift instrument articulates the restrictions. You really don't want to have to go back to the donor to request modification later if you can avoid it. So I would just say be really careful on the front end to negotiate for terms that make the most sense for the organization and avoid the temptation to just agree to whatever specific requests the donor may have on the front end. I would also say it's really helpful if you have a template set of maybe an endowment fund agreement, a general gift agreement, maybe a fund agreement where it's spend down or a pass-through fund agreement. Again, much like the difficulty in having funds that are all subject to different spending rates, having all sorts of funds that are subject to different terms can be challenging, and making sure you're staying true and honoring the specific terms that are in each agreement. It's much easier if you have like a template set and maybe if there's a variation or two specific to a donor, but much easier to start from a template set so that you have uniformity and it makes it easier to administer. Next slide. So we've focused on the terms and like accepting gifts and grants, and now looking at managing these institutional funds and some key things to think about when you're managing institutional funds. I believe all of you are Indiana-based organizations, which makes it a little bit easier because you're all subject to Indiana's, or assuming you're in Indiana, you're all subject to Indiana's version of MIFA, which is the Uniform Prudent Management of Institutional Funds Act. It just rolls off the tongue. But it's a standardized uniform act that has been adopted by just about every state. I think Pennsylvania might be one of the last holdouts, with some variation. And we'll get to one of those points here where I think Indiana law is a little bit more favorable than some states, but it governs institutional funds and and we'll look at a little bit on the next slide too, what institutional funds are, but generally it's talking about funds that are held for investment purposes by the organization exclusively for charitable purposes. So we're not talking about a fund where there's a third-party trustee, and we're not talking about like a charitable asset that's not held for investment purposes. So like land or something like that. We're talking about cash in a fund. Next slide. Two key points when we're talking about funds that are not subject to a MIFA. We're generally talking about donor restricted funds when we're talking about modifying and managing institutional funds. To the extent that your board has a surplus, which is a great problem to have, or there's extra funds, and you take funds that are unrestricted, that a donor did not restrict for a charitable purpose, and the board self-restricts those funds, says, hey, we want to set these funds aside to establish an endowment, that is not subject to modification under a MIFA. You know, the board, if the board established the restriction on its own, the board can undo that restriction on its own. It doesn't need to go to the attorney general or any other process for board restricted funds. Similarly, to the extent you have a donor who just writes a check to the organization and you can use that gift for whatever purposes you want, that is not subject to modification under a MIFA. You can use those funds however you want without, you know, and if you change your mind about how you want to use those funds, that's fine. That does not require formal modification. What we're talking about here, especially as we look at modification, are where the donor has expressed an intended purpose or restriction on an institutional fund. Next slide. One thing I think that's helpful to keep in mind is a lot of times, you know, organizations will say, well, like, what's the risk if we don't follow donor intent? And I think a lot of times donors will not have standing to bring a claim about a donation that they made if it's a completed gift. But the Attorney General is really charged with oversight over all charitable assets within the state. And they have broad authority to sort of oversee the charitable dollars within the state. So that's really where most of your accountability is going to be. And then as we'll see here, MIFA specifically does carve out a role for the Attorney General with respect to institutional funds. Next slide. So if you have a fund, and this ends up being like a fairly common problem, where you have a fund that maybe was established, it could be recently, but often more the case, you know, 30, 40 years ago, and you cannot use it for whatever reason, or it doesn't make sense for the organization to hold on to for whatever reason, how can you modify that? So maybe like a scholarship that benefits a school that's no longer in existence, maybe it supports a program that you no longer operate, you know, for whatever reason, just the restriction doesn't make sense for the organization anymore. How can you modify the terms of a gift instrument and a donor restriction in a gift instrument? There's four main ways under MIFA. The terms of the gift instrument itself may permit it, and we'll look at all of these, and we're donor consent, notice to the Attorney General for small and older funds, and then there's a court petition process. Next slide. Modification in the gift instrument. This is, and you know, this is one of the key terms I mentioned earlier. This is, I would say, the number one thing you can do to help your organization as you think about endowment funds is to just make sure you build in a modification provision into the gift instrument, so that if something changes and you can't use the fund as originally intended, that you don't have to do anything more than the board make a determination that the modification provision applies, and you can modify it as needed. The language in the statute is, you know, if the fund becomes impracticable or impossible. So sometimes that language will be used. Here I put up just a sample provision from like an endowment fund agreement, which says the board has the ability to modify a restriction If in the board's judgment, it becomes unnecessary, incapable of fulfillment, which could be like an impossibility, or inconsistent with the charitable or other exempt purposes of the organization. So just, you know, if you can't just modify it at will, but if it becomes impossible or impractical for the organization to administer this fund with this term, you can modify it. And then a lot of times there'll be language which also says you'll modify it as closely as possible to the donor's original intent. So you're not trying to just take what the donor gave you and use it for a totally different purpose, but use it as closely as possible. Okay, so that's the first way to modify. Next slide. Donor consent. And here, again, this is really only going to apply if the donor is still living. If and you can have a very simple signed writing where the donor can agree to a modification. I think one thing to keep in mind is that sometimes organizations think, oh, well, you know, the donors aren't living, but their kids can modify it. And really, it's only the donors themselves that can modify it. And it makes sense because the kids may have different priorities or different thoughts on how the parents should have used their money. But so generally, you need the donors themselves to be able to sign off on a modification. Or the agreement itself, and this is the second bullet point here, can specify who has the authority to modify. So parents may say, you know, our descendants can approve any modification, or like sometimes in the case of like a national organization that has chapters, you may say like the officer of the local chapter can approve modification or something like that. But just being clear about, you know, if there's going to be certain people who are identified as having the authority to consent to modifications, that's clear in the agreement. Next slide. This is where Indiana law, I think, is favorable, and this is where sometimes there is a variation by state law. In Indiana, if there's a restriction in a gift instrument, and again, here it tracks with the language in the statute, if it's unlawful, impracticable, impossible, or wasteful, and sometimes that wasteful comes in handy where you have a really small endowment fund, like maybe $5,000, that's just not spending off enough and it's wasteful for you to continue to manage it. And the fund is less than $250,000 and more than 20 years old. Then you can just provide notice to the Attorney General. And if you don't hear from them within 60 days, you can modify it as you know, tell the Attorney General you plan to. And it's done. You know, you just have to wait that 60 days. You can send a letter to the Attorney General. There's a charities division where you can send them. This is where Indiana law is helpful, as I said, because 250,000 is a relatively high threshold. Some states, it's if the fund is less than 50,000 or something smaller, but 250,000 is pretty generous. So if you have funds that are more than 20 years old and have less than $250,000 and the purpose needs to be modified, you can generally just notice the AG and wait the 60 days and then proceed with your modification. Next slide. The more burdensome process is the court petition process, which has to be followed for funds that are less than 20 years or hold more than $250,000 in assets. And in this case, you notice generally it's like the probate court, or you file a petition with the probate court and you have to notice the Attorney General in these cases. And then the Attorney General, you can go to the next slide, may waive may, you know, agree to it and it's fine, but generally there will be a hearing unless, you know, the Attorney General says no objection, but the judge will then issue an order either granting the modification or not. Generally they will grant it, but one thing to keep in mind with the court petition process is it is a public record. So, you know, people in the community will see that you're doing this and that, you know, you're seeking a modification, which may be totally fine, but sometimes there's circumstances in which you don't really want that to be a public process, different reputational concerns and whatnot. All right, last slide, so I can hand it over to Dory. And this is, I think, hopefully a helpful sort of checklist to the extent you have funds and you're looking at them and saying, okay, can we modify these? How would we modify these? Just starting with, is this restriction unlawful, impractical, wasteful, or is it just something like minor that we can't live with? You know, is there a gift agreement? What are the terms? Is there just, do we have just records of emails or letters? Does the document itself say how we can modify it? If the donor is still alive, would they agree to a modification? That would be great if they would. Or does the agreement itself allow modification? And then to the extent that the agreement itself does not allow modification and the donor is not living, then thinking through, when did how old is the agreement? Is it more than 20 years? Does it have less than $250,000? Could we just notice the Attorney General, or when need to pursue the court petition process? And with that, I have not left much time for Dory, but I'm going to hand it over to Dory now.
It's okay. We can get through data protection quickly and hopefully leave a few minutes for questions. So as Heather and Joe mentioned, Dory Kane here to talk to everyone about privacy. And privacy is similar to kind of what Joe was talking about on the contract basis. Privacy differs throughout all organizations. There are different types of information being collected, different privacy laws in play. And so it's really important for organizations to understand what data is flowing in and what statutes are protecting that. Protected information has obviously the types of information may not have expanded, but what is deemed personal information has certainly expanded under privacy laws, especially in the last, let's say, 5-7 years. So you're looking at in your organization potentially things like donor information, minor information, website tracking, that is a big one these days, employee and job applicant information, and then information received from governmental agencies. And so all of these different data flows could be impacted by different privacy statutes. Next slide, please. Nonprofits live in I like to say a nice world, a nice area of the privacy world, in that a lot of, well, we have our state privacy statutes and a lot of them do exclude nonprofits. Specifically Indiana, you may have heard about that, passed a privacy law, oh my gosh, 2 years ago, although it does not go into effect until 2026, January 1st, 2026. And so that law, just remember, as you start hearing more and more about it, does exclude nonprofits. But there are other obligations, right? So you may have a website privacy policy that you have in place that dictates how the organization is going to use and disclose information, ethical obligations, confidentiality provisions. If you've entered into a contract with a source to gather information for your organization, there may be protocols on how you can use and disclose that. So it's important to look at all these different areas. The biggest one, especially in the nonprofit space, is probably the cybersecurity side of things. If there is any type of cybersecurity incident that could lead to reputational risk, financial risk, that is big in the nonprofit space. And so any type of event where individuals are hearing that, potentially your organization is not protecting their information appropriately or using and disclosing it in a way that is in violation of contract statutes, notices, consents, things like that, reputationally, that is not great. Next slide, please. So this just gives you a taste. The US, you all may have heard about GDPR, which is Europe's, EU, UK's privacy statute. That is a single comprehensive federal privacy law that they have. The US, of course, takes a very piecemeal approach to privacy. And so you'll have different statutes govern things like if you're collecting health information protected, potentially from providers or insurance companies, things like that, you have HIPAA. If you're sending text messages, you may be running into TCPA, accepting credit cards, we have PCI DSS. And then all 50 states have their own breach notification statute. So it's important for your organization to really understand which of these statutes are applicable, and then running through that analysis, and then obviously ensuring that appropriate safeguards are in place to adhere to these statutes. Things like TCPA, that's going to be your biggest statute. That's, again, text messaging or auto dialer calls. that is going to be one of your only states that requires consent, or it's an opt-in statute. And so you have to opt in before the organization can send those types of communications. US is privacy statutes are mostly on the opt-out front. And because that's an opt-in state, you also see a lot of litigation around that. So litigation risk obviously associated with these statutes, violations of these statutes as well. Next slide, please. So I mentioned earlier why you should care about this. Obviously, you know, we're here to ensure that you're complying with law generally. However, you also have the financial risk associated with not appropriately safeguarding information. I pulled this, the IBM, that source I list below, that is a really good one if you're ever struggling at the executive or board level with, okay, you know, should we put money into cybersecurity and privacy safeguards, things like that. I find it's really helpful when talking to leadership to understand what the cost associated with being proactive instead of reactive is. And so with this, you can see the average cost, and this is just a regular run-of-the-mill data breach, is $4.88 million. Breaking it down even further, right? You're thinking about, well, how many records does my organization collect? And you can multiply that number by $184. So that's about the US average cost per record. Next, please. And then you see here, I said that's your run-of-the-mill breach. You also have mega breaches, which you're running $42 million on average, and then 50 million records. It's around $375 million. Very, very expensive. Next slide. So when you're talking to leadership, okay, what can we do to decrease, you know, like if we're putting money in, what are we going to get out of this? And I love to point to these metrics, because you can see exactly what works and what will reduce those breach costs if your organization is ever hit. So here you have your biggest one being employee training, right? We're seeing a lot of phishing, business email compromise type incidents occurring. And so with that, having your employees really understand, when should I be going, you know, picking up the phone and asking, should I be sending money to this organization? How do I know what's a phishing email? Things like that go, as you can see, a very long way, $250,000. You know, you can save just by ensuring your employees are aware. Machine learning, AI. We have all heard all about AI in the past few years. That's a big one on the cybersecurity front, just implementing AI to detect certain type of cybersecurity incidents. And then incident response planning is another one I always say, like just knowing how to respond in the event that the privacy of your information is breached, extremely important there. Next slide. So look at that, Heather and Joe. We have 2 minutes to answer any questions you may have.
Yes, and I have one question that I think would be for Joe. Does a non-assignment prevent someone from subcontracting agreed services without written permission?
Great question. Answer, yes, it does prevent that. And that's precisely why you want to use the non-assignment provision.
Thank you. And then last question for the last few seconds. Is there a federal requirement process if a foundation is created using non-restricted funds and the foundation wants to dissolve and transfer the funds back to the originator?
Joe, I can take this one unless you want to, but usually, well, first of all, I guess the originator should be a C3 if the funds are going to go back to them. But typically, the articles of incorporation for the nonprofit will specify where the assets have to go at dissolution, and it usually has to be a C3, or at least used for C3 purposes, maybe a government entity or something along those lines. So the biggest requirement is that you need to comply with your dissolution clause, but then within C3, making sure that all the assets, even at dissolution, go to another C3. But generally it would be permissible as long as the original contributor or donor to the organization is a C3, it would be fine for the assets to revert that way.
Thank you so much. Thank you so much to our speakers and for the wonderful presentation. Changing gears, I want to talk about a new IYI event that we have coming up. Join us for the 2025 National Summit on Youth Wellbeing, a virtual summit hosted by Indiana Youth Institute that's all about tackling the big challenges facing today's youth. We're zeroing in on the kids who often get overlooked, those from low-income families, communities of color, immigrant backgrounds, and kids who have been through challenges like trauma or neglect. This summit brings together expert speakers from across the country to share their knowledge and give you real-world strategies to make a difference. So if you're passionate about creating space where all kids can thrive, this summit is for you. Our next webinar, Empowering Emotional Resilience and Distress Tolerance in Youth, is scheduled for next Wednesday, March 19th. All of IYI's upcoming events can be found on the website listed. And then to receive the latest updates and opportunities by signing up for our newsletter at iyyi.org/newsletters. As we conclude, I sincerely thank you for being with us today. We appreciate your impact, voice, and choice to learn and partner with IYI today. Later, you will receive an email that includes a copy of the presentation and a link to complete an evaluation of this webinar. Please take a few minutes to let us know what you thought about today's presentation. Upon completion, you will be redirected to your certificate of completion. And if you don't receive the evaluation email, check your junk as it may have been directed there. This concludes our presentation, and on behalf of Indiana's youth, thank you again for showing up today and every day for Indiana youth.